continuing acts. Let me begin this lecture by stating the facts of the case I always find a little amusing and funny. In Fagan versus MPC 1969, the defendant was directed by a police officer to pull over at the curb and stop his car. The defendant did so, but drove over policeman's foot. The defendant maintained that this was accidental. But there's more to these facts. Interestingly, when he was told to remove the car, he swore at the officer and switched off the engine. The issue as to whether the Actus Reas coincided with the mens rea was raised at an appeal against conviction for assaulting a police officer in the execution of his duty. Okay, so the defendant argued that there lacked coincidence between when he drove onto the policeman's foot, that is to say at the time of Actus Reas, there was no mens rea because the incident was purely accident. The subsequent act of failing to remove the car, doing nothing in other words, meant that when he formed the mens rea, the Actus Reas was missing because it amounted to an omission and as such could not give rise to liability. Even though the failure to remove the car was intentional, nor could coincidence occur later when the defendant switched off the engine and kept the car on officer's foot because this amounted to a separate act and an omission. An omission ordinarily does not give rise to criminal liability. The Court of Appeal took the view that the subsequent failure to remove the vehicle was not a separate act but a continuous act and not an omission. The result being that it was easier to see that at the same point in the defendant's conduct and action, he must have acted in such a way to cause harm to the police officer. So, there would have been coincidence at the same point. So basically, the Court of Appeal upheld the conviction and stated that driving on policeman's foot and staying on his foot were part of a continuing act. Same line of reasoning was used in Thabu Mali versus R. 1954, where the four appellants were convicted of murder. They had planned to kill a man and then make it look like an accident. They took him to a hut, beat him over the head. Believing that he was dead, they then took his body to the cliff and threw it off. Medical evidence showed that the deceased died from exposure of being left at the bottom of the cliff and not from the blow to the head. They appealed against their convictions on the grounds that the Actus Reas and mens rea of the crime did not coincide. That is to say, when they formed the intention to kill, there was no Actus Reas as the man was still alive. When they threw him off the cliff, there was no mens rea as they cannot intend to kill someone they believed was already dead. The convictions were upheld. It was held that the act of beating him and throwing him off the cliff was one continuing act. We will look at this case again in the next lecture, as some jurists are of the view that the court's approach was slightly different. But for right now, let's look at another case. In DPP versus Ray 1973, the House of Lords preferred to look upon the matter as a continuing act or conduct. The case concerned the defendant's conduct in taking off without payment at his subsequent conviction under Section 16 of the Theft Act 1968. The accused has remained seated in the restaurant even though he realized he was unable to pay the bill. By remaining at the table and creating the impression and continuing to create the impression that he was an honest customer and had every intention to pay, he misled the staff at the restaurant. The waiters believe there was no problem and they left the dining area unattended. The defendant had waited for such an opportunity, and as soon as the waiter had gone out of the restaurant to the kitchen, he ran off. The majority of the House saw this as part of a defendant's continuing conduct and upheld his conviction. It is perhaps worth mentioning that the concept of coincidence should not be considered as an isolated principle, but should be considered in a common sense practical way in the light of all the circumstances and in such a way that would make sense to the jury. A victim will consider that they have been subjected to force and theft, and in their mind that will amount to a robbery. They may not be remotely interested in any theoretical notion of coincidence. This was illustrated in R versus Hale, 1978, which concerned the offense of robbery where the application of force and the theft took place in different locations. It was not possible to be sure about the timing, but the Court of Appeals accepted that they were concerned with the continuing act and upheld the conviction. The defendant and his accomplice were wearing stocking masks and forced their way into the victim's house. The defendant put his hand over the victim's mouth to keep her quiet and then later tied her up. The accomplice went downstairs and took a jewelry box from the bedroom. The defendant tried to argue that the theft was complete by the time the victim was tied up and gagged and not immediately before or at the time of the stolen jewelry, and as a result, robbery could not be charged. The court disagreed and took the view that appropriation was a continuous act and the matter had been properly left for the jury to decide.